Like the comments. This is another episode of Bibles and Bills. Bibles and Bills by Official Essentials. Original issue discount. My apology. Original issue deposit. The reason I said original issue discount is because that is the common use of the 1099 OID. And so when you see instructional videos for the use of the 1099 OID, generally from what I've seen, I'll just say generally from and based on the videos that I have come across, and I have done quite a bit of research, and searching again, and searching some more. And so from that extensive search, I found a common thread amongst the content that's provided for uh, ex- explanation type of videos or how-to type of videos, um, explaining what the use of the form is for. But like I said, the instructional videos are generally for people who um, understand common uses of these type of documents and forms. So if you are a uncommon user or creator, uncommon creator, and those are both one and the same, okay? And that's why it was just easier for me to say uncommon user. Because if you're using someone else's form, then you're a user. You're not a creator, you're a user, okay? But you're still an uncommon user, okay? For example, there are certain types of, okay, there are hundreds, from what I'm told, hundreds of different types of motions, okay? But there are only, I think the man said like 30 something that are in common use. Look at the percentage of commonality between the amount that's available. That's what's uncommon. So it's not that, say, for example, the other types of motions can't be used. It's just that it's just not common for them to be used. Okay? So you're an uncommon form user. If you're an uncommon form user, then you would still sort of fit in that category of uniqueness, okay? But the most dominant domain is originally created forms. And that's what Bibles and Bills is. Originally created form of a concept. And it is our trademark because we um, disseminate information in this model. The model is the balance between the natural and the spiritual. The natural and the spiritual. And so people who are latching on, they're latchers, okay, need to understand the full concept, okay? Home mortgages, notes, remedy, redemption, vouchers, probate court processes, um, how to deeds and trust content creators, and um, court review creators, law content on standing and grounds, okay? Um, and definitely on standing and grounds. People who are creating videos about standing, a lot of times they don't have any grounds upon which they standing on, no evidence to back up their allegations. And so they don't have no stand. They find that they don't have no standing in law. Okay, no jurisdiction. They claiming that the court don't have jurisdiction while giving the court jurisdiction. Because when you're incompetent, that gives jurisdiction to another. No matter who it is, it ain't gonna be you. That's how jurisdiction works. Somebody got to take jurisdiction over you because you can't jurisdict yourself. You're not jurisdictioning yourself well, somebody gonna have to jurisdiction you. That means they gonna have to serve justice on you. You know how people say, and I know I've said this many times before, especially when I've encountered unfavorable conditions, predicaments, because when something bad happened, or what I perceive to be as bad, God just bless me, bless me, bless me, bless me, bless me, to the point now I'm like, anytime something that seemed to be bad happened, I'm like, God, what you doing? You trying to set me up? I know you up to something. That's your style. So that's what Bibles and Bills is about. Them the grounds I'm standing on. The law of increase. That because I put a lot of good, I sold a lot into good works. It is a must, and it shall increase. That's why when the people in the systems who are stealing, trying to steal from my estate, in the background, I might not have knew what was going on with these bills of exchange to understand thoroughly what's going on with the bills of exchange. But if you look at our older videos, you will see that even in our videos of donations, it says, let's make an exchange. Let's make an exchange. All right? Let's make an exchange, an even exchange, you know. And because the law doesn't allow a nonprofit to make what the general public may think is an even exchange, um, nonprofits are allowed to charge administrative fees, okay? And those fees are generally priced at an amount that's nothing in comparison to the general market for those type of services or products. So the price comparison it can be equated as the contribution, as a public contribution. In other words, if you have um, thrift store and it's supposed to be a charitable uh, entity, a lot of these thrift stores are in violation because the value of the item that you get when you donate is supposed to be, because when you go to a thrift store, that is supposed to be a donation. It's not supposed to be a standard market purchase. And when you go in these thrift stores, they don't even allow you to negotiate. Like, it's set in stone. So that's really um, regular business activity. And I need to report their asses. Because I like thrift stores. That's where you're supposed to get treasures from at a minimal price in comparison to where you would go to an antique store or something like that and have to pay a lot of money to get little treasures. Okay? And artifacts and so forth. And so it's not um, equivalent to the value that you would normally pay in a retail store. Okay? So many of these so-called uh, charity organizations are operating for profit at this point in their retail outlets. Salvation Army has gotten to the point where their prices are equivalent to any retail store. Goodwill has gotten to the point where their prices are been to the point where their prices are equivalent to a regular retail store. Value Village. These are all major outlets that are supposed to be uh, general thrift stores, public uh, benefits, charitable operations. And even Salvation Army, they claiming that they helping people with their utilities, and they won't even actually issue the voucher until you get, they ain't gonna give you but $30, which is generally not even a third of what your bill is. And you have to scrape up the rest before they'll even give you that. And they making gazillions of dollars off of the free donations that they receive. Somebody not calculating up something right. It's a miscalculation going on. And I just audited the books right there on the record that these books ain't balanced properly. If Salvation Army want to operate as a regular thrift store business, retail business, then it ain't no thrift store. It's a retail business. A used, what you call that, resale store. Where there's not no thrift. A thrift is a public benefit. Supposed to be able to go there and get treasures. And redeem treasures. They ain't got nothing but trash in these thrift stores. You say, why you wealthy and you worried about thrift stores? I'm worried about thrift stores because I know where the wealth used to be at, baby. Hush your mouth up and pay attention to grown folks. Stay out of grown folk business. Or pay attention enough so you can mature to an understanding to know where the money at, baby. I'm trying to point you to where the money at. While you going up in Walmart buying your cheap ass clothes, you could have went up in any one of them stores I just named and got you something name brand. Something not just name brand, but you could have went in there and got you some good quality materials to put on clothes to put on your back. Instead of taking your ass up in there in Walmart where they rip you off, where the price don't even be what it say on the counter, what it had on the rack. All these department stores is departing our money away for bullshit. And that's their department, to consume your money for things that are not of value, that don't last. Stuff that's supposed to last, food, perishables, not supposed to last. They making the damn vegetables where the vegetables last in 3 weeks. I don't need my motherfucking vegetables to last no 3. A real tomato not supposed to last that damn long. I don't want my shit lasting that long. That's unnatural. Something wrong with it. They ain't probably got the nutrients in it and I want anyway. That part. Grown folk talk. You understand? This grown folk talk. On grounds and jurisdiction many is not familiar with because you're not understanding the economy. What makes the world turn? You know that song, people make the world go round. I don't know what the name of that song is, but I'm saying you remember the lyrics, the hook. It hooked us with them lyrics, that original issue. You understand? And we could relate to that. But the song was still an original issue in a song form, okay? That's what made it original. It was about things we deal with every day that's common. So it wasn't an original idea to say people make the world go round. It was the original way to say it. In a song. This original issue in real time. We provide content, anything and everything, all about affidavits in the United States. I'm not familiar with the policies and standards and procedures of other countries at this time. I do know they have a lot of cross-correlating processes. So I will say that. But this is about original issues made in America, baby. Made in America. I notice I didn't say made in the United States. Okay? Now, I do have hashtag United States together without no space in between the states. Okay? Because what is separating us is what's supposed to unite us. The very thing that's separating us is the thing that's supposed to unite us. That's what the flag is about with all them stars on there. It's about uniting a nation of people. It's not about uniting the states, but the state of mind, all in one. You see that all in on this channel? That's what that means. All in one. You can learn here. I guarantee you, you will not view a video and waste your time. You will not waste your time viewing content. You can trust us. You can rely on us to provide you content that will feed you good nourishment, even if it's a comment. You know, people look at the comments on the videos all the time and kind of do what I call comment mining, okay? And so I basically made a forum specifically geared towards comments, investing in comments, okay? So that's why you'll see videos like with the similarly situated thumbnail or advertisement on it, such as this. You know, say comments, and it'll have some type of notation as to what the comment is about. Is it a reply to a comment, or if it's a comment related to some other content. And so in this type of video content, we're not just commenting. We have dedicated a whole video to respond to a commenter, which means that we're vested, we're invested in what people have to say, because we understand that people make the world go round. We're not just saying it, we're doing it. We're in action, actively investing in people and their ideas and what their thoughts and what they have to say and their contribution to our ecosystem and their portion that they're providing. If they have questions, if they are seeking, they need answers. And this is where you can get them. They need verified answers. Ain't nobody looking for a lie. There's lies everywhere. Obviously, amicably, people are seeking for truth. They're not seeking for better liars. People that are better at being liars, who are skilled and crafty liars, who hide in dishonor, and hide behind the curtains of dishonor. Sneak in the window, hoping the house is abandoned, coming in like vagrants and squatters. Talking about estates and trust. With a state of mind without any honor. A trust in what? What are we trusting in? You have no business building trust. Draft your fucking will and be done with it. If you got something. It's how we do it over here. Live, real, and raw. That's the law. If you want to learn all about affidavits, affirmed affiance. Affirm affiance. Affirm affiance meaning that you're going to stand by your word. Your word is bond. What is a bill of goods? What is a bill of goods? Some people don't even know if they're selling goods or services. Some people don't even know if they were sold goods or services. Why in the hell are you talking about you can manage and you the general manager, a general executor of a trust? Are you serious right now? Man, get off the gas. Do you know what does the Bible have to do with the laws of the land? Come on. Go ask your favorite guru and find out what answer they give you. Come back. I ain't going to even see it because then they already listening to my broadcast and stealing information. You go ask them and then come back and then I'll tell you what the real answer is. And I'll prove it to you that they daubing off in the shit they don't got no business. Ask them, what does the Bible have to do with the laws of the land? Go ask them. Go to your favorite guru. Master, answer this question. What does the Bible have to do with the laws of the land? Since you want to mimic all my content. What does the Bible have to do with the laws of the land? You need to learn that. That's your lesson right there, Master. You need to learn that. That's your, what do you call that? Your homework lesson. Because you be doing the most. And don't like to give people credit. You got a taker spirit. You need to stop that. I love you. Bible say he chasing whom he loves. Who is the Bible about? We always talk about Bibles and bills. Who is the Bible about? Why do Candy always say all the promises in the book ain't yours? Why do she say that? And she says so emphatically like that's the end of it. It is. It's the beginning and the end of all knowledge. It's the beginning and the end. Once you realize that, then you'll stop chasing somebody else's destiny. And then you can get your own inheritance. The only reason all the promises in the book ain't yours is because you ain't keeping the promises in the book. You ain't no holder. You got to be a holder. Got to know how to hold. David said, thy word have I hidden in my heart, that I might not sin against thee. You think he was talking about God? Absolutely not. What he was saying is the word of truth is in his DNA structure. He embedded it in his DNA structure so that he wouldn't forget where he comes from. So he wouldn't forget his heritage. He noticed that this shit is in my bones. I'm staying with a responsibility. Can't get away from it. No matter where I go, people, I see other people getting away with doing wrong shit. But it seems like I always get singled out. As soon as I do any kind of thing wrong, I'm singled out. You know why? Because you're accountable. It's not about what everybody else doing. You are accountable. If you're one of the chosen, you are accountable. They are not. And you're trying to hold people, other people, accountable for what you are responsible for. If you're a G. If you ain't a G, then I ain't talking to you. You just keep doing what you're doing. Keep doing what you're doing, baby. Just keep on doing what you're doing. Because you're not a G anyway. All right? You're gonna keep on with your shenanigans anyway because you are what the Bible refers to as a child of perdition. You're a child of perdition. I think it's what it's called. Y'all look the shit up. I know what I'm talking about. Child of perdition. P-A-R-D-I-T-I-O-N. Perdition. They ain't really full blood. They've been contaminated. And you can't uncontaminate them. You just gotta start over. Sorry. You just gotta start over. Watch that out. That's why God allowed some people, they don't even have no children. Because their seed is cursed. You see a man having a bunch of girls, his seed cursed. Yep. If you see a man having a bunch of girls, it's because his seed is cursed. Or his seed might not have been cursed. Her womb, the woman's womb might be cursed. This is why you'll see the women in the Bible praying for a son. Because the son is the one who carries the seed of the father. Okay? Now, if you have a bunch of girls, the flip side of that is if you start having an equivalent amount of boys, then that flips it. That means your seed is super blessed. It's super blessed. I mean, you got if you got equal of both sides, say you got 2 boys and 2 girls. Well, that means you got both of y'all seed is blessed, because it's just as much of a blessing to have girls as it is to have boys, because a new seed, a new bloodline can be created. If the father's bloodline is cursed, right? He can rejuvenate himself through the woman. He can rejuvenate himself through the woman. You give them girls your name. Yeah, that's why you see women with men names. A woman can carry the seed of a man. See, society done touch y'all a bunch of shit don't even make no sense, and then y'all go around like y'all gurus repeating the bullshit that don't even make no sense. Ain't there one of y'all peons thought to think about it? Y'all don't do no thinking. That's what make you a peon. You don't do no thinking. How in the world can a man carry the damn seed? That's only in your society. The man carry on the family name. Well, how in the hell that is when Queen Elizabeth, that bitch just died, and she been carrying on the kingdom for a mighty long time. That bitch lived to be 199. Shit. The hell y'all talking about? Don't make no sense. And because people take stuff too far past what it is. The woman is the soul of creation. I don't give a fuck what you talking about. Yes, a man carried a I heard the man in the tree, or the man in the woods. He said, now he be speaking some truth now, but you can tell he got it from somebody else. But he be speaking some truth though. That means he's attracted to truth. But he said the woman do not carry the seed. That's why a man is not supposed to ejaculate outside of the woman when he is having an orgasm, because he carrying the seed, and that's like a dishonor to his seed to not try to perpetuate himself. Okay? But okay, if the man's seed is so awesome, then why he too stupid to know he needs to perpetuate himself? Why is it's the woman who wants to carry his seed if he's so important? Come on now. Talk to me. Tell me that. This was something what men don't know about women. I'm going to let you in on a little secret to help you calculate a little better. Understanding, don't get it from somebody else. Get it from reality. Okay? Because they told you that bullshit ass story and Adam and Eve ass story. And I tell you, you gonna learn the real version of that. All right? The Adam and Eve story of Adam and Eve on this platform. You want to learn the truth. Okay? You're gonna learn it on this platform if you want to learn it. Because that's what is being provided. Okay? The truth. Now, I'm not going to go through the whole story of Adam and Eve. I need to pull up my videos where I already went through that. Okay? But I will tell you this. Okay? You need to start thinking about stuff when people just heard a lot of stuff that sound good. He even threw me for a loop when he said that, because I have to agree with the aspect that the man does carry the seed. Okay? But what he doesn't understand is you got to have an incubator. The man can't. This is the reason why the man can't. The Bible says it's a sin for the man to let his seed hit the ground. Because them sorry motherfuckers, some of them they ain't strong enough. That's why some men have to get treatment. Because some people fishes ain't even strong enough to even swim up river. Some of your little engines couldn't. Especially if your libido is not up to par. How many children you got? How many women you done laid with? You done contaminated your seed with? You ain't know that. Why men don't know they'll know some shit, think they know some shit, and come with some shit like that. Yeah, our seed is important. But don't know that your seed ain't nearby as important as the carrier. I'll give you a good example. We talking about Bibles and bells, okay? Now, the story of Jesus, for those people who believe in Jesus, as awesome as the story is, that's a seed. They call it the good news, okay? That's the seed, the witness, right? But it's only a witness if somebody tell it, retell it, and tell it and retell it, tell it and retell it, tell it and retell it. Okay? Keep telling the story. The evangelists, the people who can carry the story on. So your seed ain't shit without the incubator. And that's the one that had to carry your seed. The woman that believe in you enough to won't even carry your raggedy ass seed. And I say raggedy ass seed is because the men that think they so awesome is the one with the worst seed bloodline. My ex-mate, and I'm not saying this to be mean and vicious or nothing like that. I'm just being realistic. My ex-mate, he had two boys to die. Two of his boys died. He had a lot of kids, but two of his boys is dead. Died as babies, young age. God cut his seed off. The only one living is in the Navy, trying to be honorable. Okay? And I don't even think that was to his charge. Like I said, the woman's seed can be blessed. The woman. And so that make you super blessed. That's why that one woman that has the son by him, she only has one child and he was a son. Because her seed is blessed. People don't understand that whether you believe in stuff or not. People are like, I believe this, I believe that, I believe this what I think. It don't matter what you think. Your vote don't count. I ain't gonna yes I am gonna keep telling you that. Your vote don't count and all the promises in the book ain't yours. That's the Bibles and bills. But the other way around. The votes represent the bills and the promises represent the Bibles. Okay? That's why they have promissory notes. They got it from the Bible. Promises in the book. Okay? That's why all the promises in the book ain't yours. All the promises in the book is mine because I claim them for myself. And how you claim the promises for yourself is by getting in alignment with the promises. Because there's some requirements. Tell you about the requirements for the inheritance of the kingdom. The Bible said the peacemakers shall inherit the earth. A peacemaker is not a person who let people run over them. A peacemaker is someone that'll put a stop to your bullshit if you think it's a game. It's like a knight. He's standing there. He look like a statue because he ain't moving. And he look harmless because he ain't moving. As soon as you get out of line, he gonna chop your motherfucking head off. He gonna run up on you on that horse and chop your motherfucking head off. Them knights come in right. You did? Them knights come in right. Wrecking the scene, you did? And then they go back to their position. That it. They ain't there to cause no harm. They there to keep harm. They assurance. Make sure that you don't. They like bodyguards, bouncers at the club. That goodness and mercy. They standing at the gate saying, hey, hold up now. Hold up now. Wait, nah. Hold up. You coming with some chaos? Entry denied. Now what we will let you do, we'll let you stand outside the corridors so you can hear all the goodness and enjoyment going on over here on this side, so that you can get a desire to comply so that you can come on in. That's all. Otherwise, none of the promises in the book is yours. The Bible say, as soon as you store up all your goods, the moth's gonna come through and eat it. I had to learn that. I was trying to store up stuff. I had to learn. I don't have to store up nothing. All right? Because the wealth of the wicked, they storing up for me. Why I got to store up anything? They over there hoarding everything to be distributed to the wealthy, which is me, which is those it belong to, the just. Those that are honorable. And it may sound like some goody two-shoes type of trip, all right? Let's say, be honorable, do the right thing. That's only because you become dead to righteousness. That you don't even value it no more. You don't even think of it as a good thing. You think of it, oh, goody to them, you know. It's as something repulsive. That's how wicked people's hearts look at. To the point where anytime you try to tell them about doing the right thing, they try to make you out of some type of religious fanatic. Not even understanding that I don't care whether you godly or ungodly. It's rules to this. Word is bond. It's rules to this. And you got by the rules. People think prison is the worst place you can go, or either hell. You know, people think about hell, right? I'm going to tell you what hell is. Hell is when you break that bond of communion and trust, and you, what you call that? The Bible say, don't bear false witness. And you a bearer of false witness against somebody. Do them some harm for no reason. Like the creditors go and put bad shit on your credit report after you tried to pay on time and everything. And messed up your credit score. And then these banks that's borrowers, they liars and bearers of false witness, that they got all the billions and quadrillions of dollars, and these broke bitches ain't got a goddamn dime of their own. What is a bond of communion? People People always want to know about some shit having to do with some money, and ain't no such thing as money. If you can find the word money on a dollar bill, I'll pay you $1 million. Because it don't say money. It say note. Federal Reserve note. Big as shit. Back to the motherfucking question. What is a bond of communion? To my barbers and bills. A bond of communion is when you have sense enough in your mind to say, I wouldn't do this to nobody because I wouldn't want them to do that to me. It's not about being a goody two-shoes. It's about just being fair. Can you fucking just do that? That's what justice is. Fairness. Can you just be fair? Who can draft a bill? Do you know who can draft a bill? If you don't know who can draft a bill, you ain't got no business drafting no documents. If you don't know who can draft a bill, you don't got no business paying nobody to draft you no document. If you don't know who can draft the bill, the person that's creating the documents for you don't need to be creating the documents for you. If you don't know who can draft a bill, you and your guru need to be shut down. It's real talk. Truth, truth. I'm telling you how to create. You first create by unction, okay? The unction of the Holy Spirit, of pureness, of purity. By unction of purity, creativity will come. And you can draft a new bill. You can draft a new order for yourself. You can say, I'm not going to follow nobody else until I get enough understanding that when I do draft a bill, I know I can draft a bill. If the answer to that isn't I can draft the bill, if you didn't know the answer before I just told you, you can draft a bill, then you need not to be filing none of these documents. Talking about you creating a trust. Because you got to first trust in yourself. General. People talking about you're supposed to be the general executive. Man, get off the gas. You don't know who can draft the bill, you ain't no general. If you think other people's bills have power, you ain't no general. What I'm saying is, okay, they created imaginary trust. Okay, out of this bills. We need to get back to the bills of exchange so we can get down to the imaginary part of it. Okay? So, in that regard, yes, they're floating around numbers and saying, You know, they got stocks in this and they got stuff, but it's imaginary though. How you gonna draw down on that? It's like saying, I want my Monopoly money I won. Are you serious right now? Don't do that to yourself. Don't let nobody do that to you. Run you around in stupid circles. Stupid circles is where the peons hang out. And I see them sometimes. The comment section is so full of peonery. The comment section is so full of peonery that I have to equate it to the content. And what I mean by that is, well, what could you expect in the comment section of a video that's just, I don't know. And that's what I'm saying. I don't know what the fuck. You know, who set this Frankenstein free? Because that's basically what it be, a Frankenstein. You know, something people grew to love but didn't even realize this shit is uglier than a motherfucker. You know what I'm saying? That's basically what be going on with a lot of content online. You want to learn how to create documents, Bibles, and bills? Um, hang tight. I got you, baby. What we finna do is right now, we finna take it to court. You ready to go to court? Is y'all ready to go to court? We going to home court. All right? What's home court? Home court is when you learn that court begins at home. Ah, that part. It don't begin when you get in the what we all country folks call the courthouse, in the corridors. It's the correct word, corridors. But when you get in the corridors, that is not the time to start giving up praise. Praise is supposed to be sufficient at all times. And what I mean by praise is, the Bible says your work shall praise you. In other words, any evidence that you have will exonerate you from any condemnation. Or that's why kingdom workers can say with confidence, because it's their promise that no weapon that's formed against us shall prosper. Okay? And that don't apply to everybody. It just really doesn't. People need to just stop trying to pretend like they done learned some new rule that allows them to be ugly people and be blessed. Just stop it. There is no new rules like that in existence. The devil is a lie. I don't even believe in a devil. But if it is one, he is definitely a liar. That part.
Versus City Mortgage.
May it please the court, I'm Leslie M. Conklin. I represent Providence Lakes Master Association, Inc., the appellant in this case. This case comes to the court on a notice of appeal of a final judgment of foreclosure that was entered January 15, 2013. Your Honors, this case was a typical mortgage foreclosure case. It was filed September 29th, 2009. Two-count complaint. Mortgage foreclosure, count one. Second count, lost note. No copy of the promissory notes attached to the complaint. I answer and assert affirmative defenses on behalf of Providence Lakes. I admit that they don't have the note. They don't possibly know where they can find the note. It's gone. I admit that. I deny that they have the right to bring this lawsuit, and I bring an affirmative defense alleging that they have no standing, didn't attach the note. They say in paragraph 5 of the complaint that they had the note via assignment. So,
didn't the judge ask you on the standing question at some point during this colloquy that you're only interested in one piece of the pie, and that's the association fees, and that, in his mind, didn't relate to standing of who the note holder was, and issues like that? You got a monetary interest, not standing on the bank's ability to actually foreclose. Well, did you have that discussion? Because at one point, he asked you, the court says, well, let's talk about that. What are your standing at this point? And you launch into this whole argument about McLean and cross-examination and opening the case, and you never actually addressed that. Am I wrong on that, or is there, at some point, did you address that?
I thought I did. The point is, my client didn't ask to be hailed into court. We were served as a defendant. The complaint actually alleges that we had an interest in the lawsuit by virtue of, this is paragraph 14 of the complaint, Providence Lakes Master Association is joined because it may have a claim of some interest or lien in the subject property by virtue of a possible claim of lien or assessment. And then they proceed to talk about how they're suing under 718, the so-called protection.
Was there a cross-claim or an answer alleging, yes, we do have an interest and we're owed $1,000 or something like that?
No, did not file a cross-claim, did not file a counterclaim. My point being, though, we filed an answer to affirmative defenses. My argument, I thought, at court was, and I thought it was somewhere in the transcript, and that was, we're not a second-class defendant. There are defendants with some rights and no rights. We were hailed into court. Why don't we have all the constitutional rights as an association that anybody coming in? I wasn't claiming anything of the borrower. For example, although I claimed in the affirmative defenses a paragraph 22 defense, I never argued that at trial, but I did claim standing. And the point being, why, if my client's hailed as a defendant into court, why am I not able to raise whether the plaintiff has standing to bring this lawsuit? And certainly that's been defined by the 4th and the 2nd districts. I mean, I went through in the brief. The point is, what interest did they have to sue my client? They had to show that they had the original promissory note at the time, with endorsement, at the time they filed the lawsuit. Keep in mind, they don't find the note for 1,373 days. We're after pre-trial and on the dawn of trial. Also, keep in mind, they filed a lost note affidavit. The copy of the promissory note attached to the lost note affidavit, no endorsement. The copy of the trial exhibit, which they provided to me late and under court order prior to the trial, no endorsement. But all of a sudden we find the note about 20 days prior to trial, and now it has an endorsement on it. And here's the interesting part. Mr. Sokoloff at trial asked for relief from admissions. I say, congratulations. I applaud that you were able to find the note after 1,373 days. He asked for relief from admission as to one admission, admission number 8. And, Your Honor,
Mr. Conklin, before you get too far, I just wanted to ask you a question about the endorsement on the note. What was the date of it?
No date on the endorsement. It was undated.
Undated endorsement.
Correct. But as they all practically are.
But their testimony, I believe, and their position was that we lost it, we found it, but we had it at the time of the lawsuit. Was that their position?
That was. However, in that she was asked after they had closed their case. This was when I moved for involuntary dismissal, saying you had 4 exhibits admitted into evidence: the note, the mortgage, the paragraph 22 letter.
Wait a minute now. Wait a minute. Wait just a doggone minute here. Now, first of all, I made a comment, excuse me, on a previous broadcast that many lawyers don't argue standing in this manner. Okay? And that that statement still stands true because this particular case is not relevant to my statement. Because the reason I said wait a minute is because you would assume that he's arguing standing for a person. But he is not arguing standing for a person. He just said he was arguing standing on behalf of an association and they have the same rights. Okay? So, I do understand that because an association is similar and equivalent to a sole proprietorship. Okay? Some are designed as such. However, I hesitated to just say it like that because, for example, the homeowners association, they just as crooked. They're a corporation. The homeowners association don't have no clout like people be allowing them to get away with a lot of stuff. And that I don't deal with properties that are located within any type of zones of a homeowners association because that is automatic, what they call that, landlord. Even if you think you buying the property, you actually just a renter. You just a tenant. It falls under condominium rules. And so, no, I don't fuck with nothing got to do with the homeowners association. It's trash. They'll take over your property. They're nothing but land pirates. And when they capture you on their land, they swindle all your goods off your ship. They make sure they shipwreck you on their land. And so this video, I want to go ahead and hear him on out. But please be clear, he not even arguing this hard for no individual client. And so my statement still stands. I ain't never seen no lawyer argue this hard for no real client finna about to lose their house. He arguing this hard for association. Well, go right ahead, baby.
The notice of intent to foreclose and the loan history, none of which showed when they took possession of the note or when the endorsement was put on the note. None of those. I will eat those exhibits in front of the court if you can find in those 4 exhibits anything that indicates when they came into possession of the note. And so Mr. Sokoloff, after he's rested and during my motion for involuntary dismissal, asks, Your Honor, can I redirect? And I say, wow, I haven't gotten cross yet. And Judge Padgett doesn't skip a beat. Judge Padgett says, "Are you moving to reopen your case?" "Yes, Your Honor." And he says, "The witness is no longer in the witness stand. She's sitting beside Mr. Sokoloff. When did City Mortgage have this note?" "Oh, we had it before September 29th. I object again. Say this is hearsay. And then we go into that long colloquy with Judge Padgett about, well, this is just a lady from City Mortgage. I seriously doubt she was there when the note came into City Mortgage. She's just one of many employees." The point was, I must have argued every single one of the cases. I argued SAS. I argued Thompson, I argued Yost. I said, you can't have hearsay testimony with the business record coming in first. There was no business record as to when they took possession of the note. Let's get back, though, to the request for admission, because that's important. If you look at it, and it's transcript, it's R216, paragraph 17, this is the motion for relief from admissions made at trial. Paragraph 17 says, "Association will not be prejudiced if plaintiff is allowed to withdraw or amend response to admission number 8. You go to my request for admissions, I set them out in the brief, and they were several in length. Number 8 only deals with the original promissory note is lost or destroyed. All the other 11 requests for admissions were admitted. Keep in mind, I served the request for admissions with my answer and affirmative defenses. They didn't file a response. They filed a motion for extension of time to respond to make a reply to the affirmative defenses and to respond to the notice produced. They didn't ask for an extension of time as to the request for admissions. Judge Foster hears this, and he goes ahead and includes it and says, because in their motion for relief, they don't attach a proposed copy of the responses. So Judge Foster says you have 30 days from the date, this order, to file your response. Let's see, 561 days after the order, allowing them an extension of time to file responses to the request for admissions, they finally file a response. No additional motion for they never filed a motion for relief. The court heard that as part of their motion for extension as to the reply and the notice produced. So, no further motion for relief from admissions until trial, and he asked only for number 8. I read to the court number 6 and number 7. Plaintiff has no evidence that it had possession of the original promissory note on the date of filing the complaint. It's number 7. Plaintiff did not have possession of the original promissory note at the time it filed this complaint. My brief is replete with cases on no motion, no relief, no error. He asked for never has filed a motion for relief during the course of the case. Day of trial, they have a motion for relief, and he asked for relief from one request for admission. Keep in mind, the record is also replete with the fact they don't have the note. A lost note affidavit, and it's complete as far as I looked in the filing cabinets, I looked in the file, I turned City Mortgage upside down, I can't find the note. And the really comical part is the copy of the note attached has no endorsement on it. As I said, the trial exhibit that was provided to me pursuant to court order when they were late exchanging the trial exhibits, that has no endorsement on it. But we find the original note about 20 days before trial, and miraculously now it has an endorsement, undated. No evidence whatsoever. Additionally, Judge Padgett specifically said I could have cross-examination as to the amounts due and owing, and then he took that away.
What was the rationale for that? The only thing I can think of is in context he seemed to say it related to the standing issue and the amount in controversy, and you're not able to establish that you have any standing after the bank is paid off regarding a deficiency. I wasn't sure where he was going with that.
I have no idea either. I cited to him Spencer versus EMC Mortgage. I cited to him the Palacios case, which is out of the 2nd District.
I think the way I read it, in addition to all that, was he said, well, the exhibits are in evidence, they documents, they speak for themselves. It's a mathematical computation. So in essence, these are unliquidated damages that can be established through the paperwork or whether it's hearsay or hearsay exception, I think that's what he was thinking.
Yes, but there was no computation of the interest. We all took it on face value. Ms. Chamel, City Mortgage's sole witness, reads from the proposed final judgment over my objection. It's not a trial exhibit. It's prepared in anticipation of litigation, but she's reading from it as far as the interest. You think that it's liquidated and that's simple? I've won at least 3 trials where the witness said, I can calculate the interest from the witness stand, and when we took a recess, they couldn't. Here's the other thing. If you look at the loan history, and I think that was plaintiff's exhibit number 4 in evidence, the loan history starts 3 months. It misses 3 months of payments. So it starts in...
So you're saying it's not unliquidated damage. It's not liquidated damage.
Is liquidated damages, but certainly the court costs, the attorney's fees, the other things that were put in there, I wasn't heard as to those at all. And you'll find no stipulation by me that I ever agreed to any of those.
But they've submitted affidavits.
To tell you the truth, I can't remember whether they did or not. My point being, I didn't stipulate that they could prove those by affidavit. And of course, I got no cross-examination. Back to the loan history. Loan history stops August of 2012. We try this case January 15th of 2013. So we're missing 5 months. At the top end of the loan history, we're missing at least 3 months. The first payment in this case was due, I think it was, actually I don't remember. But the loan history, if you compare it to the note, they're missing the first 3 payments of the note. I certainly had something to ask Ms. Chamel about on the cross-examination. Here's the point, though. I'm asking for the court to return this case and grant my motion for involuntary dismissal. I defy anybody to find in the record, other than Ms. Chamel's hearsay testimony that they had the note at the time they filed this lawsuit, anything in the record. As I say, everything in the record shows they didn't have it. Keep in mind, they went...
Let me ask you a question.
Sure.
You're seeking involuntary dismissal as to all parties or just your client?
As to all parties, Your Honor.
Even the parties that were defaulted?
If I show that there's no standing, why isn't it no standing as to all parties? You either have standing or you don't have standing. It's not standing as to the homeowners association and no standing as to the borrower.
I'm just trying to figure out your rationale. As the homeowner who defaulted gets a default, that proves liability. They have standing to contest damages. So why would we enter an involuntary dismissal on the entire case when liability had already been basically established?
Because as to them, I understand.
You're not their lawyer.
But I'm saying standing is as to all people. The definition of standing is I have such an interest in the case that I can bring this suit. Keep in mind, I have 2 cases out of the 2nd District where I represented homeowners associations, and in both of those cases, this court found that the defendants had been defaulted in that case where I had won on standing. I was entitled to attorney's fees. That's Country Place and South Bay Lakes. So the point being, I have raised this before and raised this before this court. But you either have standing as to all parties, defaulted or not, or you don't have standing. The fact that one defendant wins and the other defendants are defaulted, I don't know how that's really pertinent. The point is, did they have the note with an endorsement in blank at the time they filed suit? Clearly, they did not. By the request for admissions, by the affidavit of lost note, by the filing of the complaint. Here's the interesting part. We go to trial. They don't even drop count 2 of the complaint. Everything that they had alleged and I answered, that was also an admission. That's the Carvel case that I cite in my brief. The point being, they didn't drop count 2. So now we're talking about BAC Funding Consortium and we're talking about Feautures. And that is, wow, we're proceeding to trial on a complaint that doesn't state a cause of action as a matter of law. Didn't move to amend, even at the close of their evidence, and certainly it would have been granted. They didn't move to amend their complaint to attach the note to the complaint. So they're proceeding on a complaint that has no note attached to it, and a viable count. They found the note, but they don't move to even drop count 2. The proper method that this court has outlined in Feautures is you need to amend the complaint. I'd like to reserve 5 minutes if I didn't mention it.
You're
right on it?
timing, yes, sir.
Very good, thank you.
morning, Your Honors. Rhiannon Funk here on behalf of the appellee. Thank you for your time this morning. So, just as an initial matter of rebuttal, Mr. Conklin has stated that there was no evidence in the record of plaintiff's standing, and I respectfully disagree. While he may contest the evidence that was presented as to the possession of the note on January 29th, 2009, which was about 8-9 months before the filing of the complaint, there were two other pieces of evidence that related to the standing and the equitable interest in this loan. There was a breach letter which was sent to the borrowers before the filing of the complaint. It was sent to the borrowers and it was sent by City Mortgage. Additionally, there was a payment history that evidenced payments received by City Mortgage from the borrowers. Those two pieces of equitable evidence would be sufficient for a court to find that this is in fact the proper party withstanding to bring this mortgage foreclosure action. So respectfully, I do disagree that we had failed to establish that there was in fact standing. While the evidence of the original note would be the best evidence, it is the better weight of the evidence at trial that should be compelling.
Did the judge actually say he didn't have standing?
No, in fact, that opposing counsel did not have, that the HOA, no. He did indicate at times that he thought the standing was limited just to the right up to assessments. I do know that the association did address an additional right to redemption that they were claiming, though it is our position that in fact they did not hold that interest in the right of redemption, which is generally limited to the mortgagor or their successors or other mortgagees. So with that being said, again, my position is that this case is about two competing notions of standing: that of the plaintiff in this case, the appellee, and that of the association. We believe that through the evidence that was presented to the court that we have established standing based upon the borrower's own default and admission by default of their obligation under the...
Well, do you disagree he had standing to conduct cross-examination?
I think that he had standing to conduct cross-examination, but it should be limited very much to the scope of their standing in the lawsuit generally.
Okay, did the judge limit it to anything? Did he even allow one question?
He didn't ultimately at the end, but that was, I believe, based upon the sort of inquiry and discussion with counsel as to the scope. My position is that opposing counsel failed to proffer failed to answer the question, which was asked 3 times, what their standing was, with any discernible, actual, and real interest. Their